Let's talk about what's the difference between an independent executor and an executor. Well, here in Texas, we have something called an independent administration. So if you've lost a loved one and that last will and testament says, I name you as the independent executor, well, you're in luck because that means you get to do the job of the executor independent of the court's oversight. Now, typically that's a really good thing. That's going to save a lot of legal fees because you get to do all the work of the executor without the court's approval. Basically, if you're listed as the independent executor, you handle the will probate, you have a basic hearing, and then basically the judge says, go forth and handle. You can sell real estate, you can sell cars, you can deal with bills, all without court oversight. That's pretty cool in most situations. Now that's opposed to just executor, or sometimes what we call a dependent executor. And as you can imagine, it's kind of the opposite. If you are just executor, and we haven't used the magic words, independent executor in the last will and testament, well, that's going to mean that everything you do as executor or dependent executor will be dependent on the court's approval. Now, let me give you kind of a wild example. Let's say your mom's passed away and as part of her estate, she has a house. Well, if you've been listed as the independent executor, you can sell that house. You could put a for sale sign in the yard the day after your probate hearing, and as the independent executor, you could close on that sale without really much paperwork from the judge at all. So that's pretty cool. It saves a lot of money. It's fast. Everybody's happy. Now, on the other hand, let's say the will that's been probated doesn't use the magic words independent executor. Well, now, if you go to sell that house, you're not going to do it the next day. Oh no. You could have as many as 5 hearings, all with a probate attorney by your side before you can sell and close on that house. So it's like totally different if you don't have the magic independent executor wording just to sell a house. And you can imagine if you have 5 hearings just to sell a house, what that does to the cost. I mean, I love my clients, but as an attorney, I'm not free. And every time I have to draw up paperwork and travel to downtown Dallas to handle a probate court hearing, it's going to cost money and it's going to create delays. So I think you have a couple morals of the story here. If you're interested in creating a will in Texas and you really trust the person that you want to handle the estate, will consider using the magic words independent executor. That way your estate can save a lot in legal fees and that independent executor can handle the estate much more quickly. Now, if you're not so sure about the person that you're thinking about as executor and you'd like to have some court oversight to make sure that every T is crossed and every I is dotted, well, don't name them independent executor. They'll be just executor or dependent executor, and the judge will have to sign off on every step that that executor takes. Now, quick note before I let you go. I've talked about executor versus independent executor, but if a person died without a will, the terminology would be administrator and independent administrator. Now, under our law here in Texas, you cannot be appointed the independent administrator of a person's estate unless all of the heirs have agreed that you can be the independent administrator of the estate. So if you have a loved one who's passed away with no will, the terminology is not executor, it's administrator. And if all of the heirs that have been determined by the judge said, hey, we're great with you being appointed as the independent administrator, then you will be able to handle all of that estate administration, like selling the house and things like that, without having the judge sign off on every step along the way.